sat down and we said to ourselves, what do we need to subpoena? How can we prove that, how can we raise a reasonable doubt with respect to the state's evidence in this case? My client had told me the story that this guy had sold him the tool. He didn't know it was stolen. The guy worked at the company, and the guy had been killed in Mexico. And so what do? We issue a subpoena to get, we had a first name, not a last name, and so that subpoena wasn't as tight as I'd like it to have been, but all I had was the guy's first name. And I said, I want this Juan's employee file. Juan is a person that had worked for this company. He was killed in Mexico and stopped working on this day. Boom. I get Juan's entire employee file. And contained in Juan's employee file was an employment agreement to abide by the tool policy. I'm like, holy cow. I was like, what's the tool policy? So then we shoot off another very pointed subpoena that is, what is your tool policy? I want a copy of the tool policy. I get about 1,000 pages of their policy in dealing with tools. And so there's this little theft case, and all of a sudden I'm going to become an expert on this company's self-serve, a large company, their employee tool policy. Me and my associate pour through the records that involve the tool policy, and we find this receipt for chips. And it's real simple. It's like you get these chips and you go in there, and if you're going to get a grinder, you give them the chip, and then they give you the grinder, and then chip 36 is missing at the end of the day, and who got chip 36? Well, this guy got chip 36, and boom, boom, boom. It's very simple. I knew more about the tool policy than anybody. They brought in the manager of the company, and he'd heard about the tool policy, but had no idea what I was talking about. And so then I'm taking these things, and then I'm not big on pre-filing records with business records affidavits. Okay, why are you going to tell the other side what you're doing? Because by telling the other side what you're going to be doing, you're not giving them a reason to dismiss the case. You're giving them the opportunity to screw you and your client. Because then what's going to happen, unfortunately, and I wish it didn't happen, but they're going to pull that witness aside, they're going to woodshed him, and they're going to cook your goose. And so I'm not real big on pre-filing documents. If I have somebody that I can come close to proving up the predicate for admissibility, I'm going to use that person. And you know what? If I can't get the document into evidence, I'm huge on refreshing people's recollection of documents. And in my opinion, you give up a huge strategic advantage when you pre-file documents. And I understand it excuses you from issuing a subpoena for the custodian of records, but it's just you're giving up a huge strategic advantage. But then in this case, we get the chip policy, and the trial becomes the chip policy. What about the chip policy? What chip was connected to this tool that was taken out? And when did this grinder go missing? And you don't even know when it went missing. And at the end of the day, it's just the jury was so pissed off about the tool policy that they were like, this is ridiculous. And I was like, boy, if you ran your company this way, how long would you be in business? And then they brought on the police officer who was just, there was nothing special about him other than he was just a prick. And it's like, you know, I'm very nice. I really am a very nice person. And, you know, I start out nice because that's just how I am. If I meet you on the street, I'm going to introduce myself and I'm going to be nice. But then, once I get to know you a little bit, I'm going to show those folks over there that you're a prick and that we can't believe you. And this cop was horrible, just absolutely horrible. And as a result of his horribleness, we ended up getting my client's statement suppressed, and then we were left with the tool policy, very quick not guilty verdict. And so that was the first trial that I had this year. And so the lesson I learned from that is the needle in the haystack, that start a little bit early, get your information, and follow up on it. Because if I hadn't gotten that policy in that case and hadn't been able to make it a trial about tool chips, then my client probably would have been convicted, you know, because it's real obvious that even the guy at the pawn shop looked at the tools and was like, yeah, that's from that company. And this guy worked for the company. So kind of challenging at first blush. But, so that was my first trial. All right. By far, this was the toughest trial that I've had in my career. And my office mate, Gene Taus, had asked me to assist him with this case, and it sounded fun. It sounded exciting at first. And then as we got into it, I just really wanted to kill Gene Taus. Because Mr. Nieves is a man originally from the Dominican Republic. And Mr. Nieves is also an habitual felon. Mr. Nieves had 2 prior felony convictions back in New York for non-sexually based offenses, but habitual felony. Mr. Nieves was accused of indecency with the child by contact with his little niece. And the state really didn't have a whole lot of evidence in this case. They had his DNA all over a hickey on her neck, okay? And then we had a little girl that was saying that Mr. Nieves had touched her on her private part. And just a little bit of challenging evidence in this case. And we tried the case against Tiffany Larson, very experienced prosecutor in this county. Very good, very effective, very thorough. I give her an A+. I was glad the jury didn't. But, so then we started looking at this DNA, and the DNA said that they couldn't exclude Mr. Nieves as a contributor to this DNA. And anytime you're dealing with a case this serious, you definitely want to consult with an expert. We had hired Dr. Michael Spence, who's out of New Mexico, and I just can't say enough good things about Dr. Spence. He's A, he's very reasonably priced. B, he's very smart. He's been qualified as an expert in multiple state court jurisdictions. He's been qualified as an expert in federal court, and he's just a credible witness, and he comes across well in front of the jury. So we send Dr. Spence this DNA evidence, and we're like, Dr. Spence, what do you think? And he's like, well, I agree that your client can't be excluded as a contributor, but look at the number of cells here. The number of cells of DNA is just, your client's accused of sucking this little girl's neck. The number of cells is no, and then I left out a part. My client gave a statement. When my client gave a statement and they asked him about the hickey, he said his wife may have done it, maybe she's lesbian, and he laughed. And it's just like, not your best moment when you're dealing with the trial where the punishment range starts at 25 and goes up to life in prison. You really wish your client didn't treat it that way. But regardless, you know, we can't change the facts. And so we really started looking at the DNA in this case, and there were 50 to 100 cells of DNA. And my expert said to me, there's no way. There's no way. Saliva is going to have 400,000 DNA cells. He's like, this is smoke and mirrors. This isn't what they're saying it is. And if I had taken that, and honestly, my guy had been in 3.5 years waiting for trial, and they offered us 8 years before trial. And I was like, oh God, I'm going to be out of here. I was so relieved. And went up and took the offer to my client. And Mr. Nieves looked at me and said, Mr. Silverman, I don't care if they give me 100 years. I didn't do it. And so I was like, okay, that's a trial. And so then we proceed to try the case. The judge tries to get him to take the offer. He won't take the offer. And the state puts on their witnesses, and they put on the little girl. She does a perfect job. And then another thing with these kind of cases is the SANE exam, the sexual assault nurse examiner's exam. Very important that you take a good, hard look at that report. And for those of you that haven't dealt with these cases, that's the nurse that comes in with the swabs and collects the evidence in the case that's going to help prove the case for the state. And the thing with these touch cases, to me, the most important thing is what are we accused of touching? Because in this case, we were accused of touching the panties, okay? And where were the panties, okay? The panties were never tested. The panties that we're accused of touching. The DNA on the neck, I brought a shirt with me. I put it under counsel table, one of my triathlon shirts, and I put on my triathlon shirt, and I walked around the courtroom when they had their DNA expert up there, and that's just, people think in pictures, okay? People aren't real good with words. People think in pictures. And so they had a picture of this funny little man walking around the courtroom with his shirt on over his dress shirt, and when their DNA expert was up there, I was like, ma'am, I was like, this transfer DNA, if my associate had been wearing this shirt and I put it on, I'm going to have his DNA on my neck, just like the complainant did in this case. The number of cells that I'm going to have on my neck is going to be consistent with the number of DNA cells that were on that child's neck. Saliva, the reason that you take a cotton swab and you swab a person is because saliva is going to have the most DNA as to any surface, the most DNA. And furthermore, that cotton swab, it's made out of cotton. So you and I can agree, the reason y'all do that is because cotton captures DNA. And everybody should kind of see where we're going with this. What else was made out of cotton in this case? The panties were made out of cotton. And so if a person touches the panties, the greatest probability of having my client's DNA on him, if this even happened, is on the panties. Where are the panties today? And then you could have, it's the crickets. The crickets are chirping. Because that person's sitting there looking at me and is like, well, I wasn't at the scene. Okay, you weren't at the scene. Okay, well, who was at the scene? Well, I don't know. I was like, I'm going to help you out. I was like, Officer so-and-so was the person at the scene. Yes, Officer so-and-so was at the scene. Okay, so Officer so-and-so should have collected it, right? So it's his fault. Is that right? And it's just, well, I guess so. Okay, well, there were these other officers. Whose fault? And then everybody can see where this is going. So then I put on my case in chief. We recalled this officer. Were you aware the DNA expert said it's your fault? And then they said, and you're taking this case that is really bad, and all of a sudden everybody's doing this, and it's like where we're going to end up in closing argument is the somebody, anybody, nobody story. Somebody could have done it, anybody could have, but nobody did. Okay? And then it's like you want to look at their DNA expert and say, you know what? Why don't you apologize to this person? Okay, you want to apologize to him because he's the one that's facing getting sent to prison the rest of his life. And solid, offensive, and solid. Ultimately, in that case, my client also insisted on testifying. Okay, insisted on testifying. Very, very, very difficult. Now, whenever you deal with people that have priors that are greater than 10 years old, you've got to file a Theus motion, okay, or Theus motion, however you pronounce it, okay? Real simple. It's like those priors are remote. They're not relevant unless your client opens the door to them. And believe me, I took my client back there and I told him, I was like, you see this pen that's in my hand? Okay, you're about to testify, you're about to get on the witness stand. If you fucking open the door, I'm going to crawl over counsel table and I'm going to stab your eyes out with this pen. I was like, if I hear anything like, I'm a good guy, I would never do anything like this before, I will fucking kill you. And then we practiced once, and it came out about the church once, and I was like, if I hear anything about the church, what you do in the church, and when my client was testifying, he wasn't looking at the prosecutor, he was waiting for me to jump up to the table and gouge his eyes out with a pen, okay? And you know what? It's like the only thing I needed out of my client's mouth was, I didn't do it. It didn't happen, period. That is all I needed. My direct examination of my client took 10 minutes, period. Okay, he wanted to get up there, fantastic. Go for it, because you're not going to screw up my case. You're not going to screw up my case. And he got it. Jury was out for 4 hours, and had sent out a couple of notes that just really concerned me. And for those of us that have tried very serious cases like this, that was a knee-buckling verdict. Okay, and for those of us that have sat in these chairs and were dealing with these cases, it was the kind of verdict that I could barely stand up. Okay, when that jury came back in the courtroom. My client, black person, I had one black person on the jury, 11 white people, kind of conservative-looking people for our county, and they acquitted my client. And just a huge case. And the biggest, once again, the lesson I learned from that case was when it comes to DNA evidence and any type of forensic evidence, evidence comes in the form of evidence, what they're going to bring you. The DNA evidence, the blood evidence, the breath test evidence, the fingerprint evidence. But you know what else evidence is? Evidence is lack of evidence. It is lack of evidence. And there is, in a case like that, you need to have your experts sitting there in the courtroom when they put on this evidence to keep them honest. Because there are things that they need to do that they don't do, and they'll play it off like you're crazy when you're asking for it. But in that case, they didn't preserve the panties, they didn't know where they were, they agreed with me that the cotton in the panties, if my client had actually touched them, would have had his DNA on it, and they weren't there. And a big reason that jury came back with that verdict is because of that. So, DNA, don't take it at face value. Evidence isn't just what they present you, it's the lack of evidence. It's what they don't do in the case. Okay? Yes?
Great testimony, which you put on about DNA and the pants.
Yeah.
How did you get that in? On cross-examination, or did you have your experts still?
We did it, well, our expert, whenever you deal with, for those of you that haven't tried a bunch of cases using expert witnesses, they can be excluded from the rule. And you have them sit in the courtroom during that portion of the testimony because it's going to help them base their opinion. So my expert was in the courtroom, but essentially my expert had prepped me and told me what to listen for, not very complicated stuff. And then I just cross-examined their witnesses, and their witnesses gave it to me. They gave it to me. And then, after I put on my expert, they tried to call somebody in rebuttal, and that's where I really finished up the Q-tip thing. Because I was like, how are you? And she was a fairly new analyst. She was so excited to be there. I was like, what do you call those things made out of wood? And she was like, Q-tips, on Q-tips. And it's like, what's the top part made out of? Cotton. I love My Cousin Benny. And these are little things like out of My Cousin Benny. And it's like, what's that stuff at the top of the Q-tip made out of? Cotton. Okay, what are panties made out of? Cotton. So you'd agree with me, just like the other expert witness said, that that would be the best way to figure out who touched what and when and where, and then we'd have forensic evidence to prove it, but y'all kind of dropped the ball on this one. And it's just, yeah, and that's how it came out. This is a Mr. Rodriguez. Okay, this was the next case that I had tried this year, and this was a DWI with a .15 blood test. And a lot of people ask me questions about trying these kind of cases, because I've tried a lot of them, and you know, what works, because these are tough. And these are very tough cases when you're dealing with a blood test. In this case, we kind of had, I'm a big advocate of utilizing 3823. And I keep giving kudos to my brother, but he taught me a lot about using Article 3823 of the Texas Code of Criminal Procedure. Because Texas is a great state, we all know that. But Texas is a unique place in that if the judge denies your motion to suppress and you raise a fact question, the jury gets to weigh in on the fact question. And earlier in my career, I used to spend a great deal of time voir diring on that. And I talked to juries about it. It's a great way to bust a panel. And you know, how I bust panels with that is I will say to the jury, you know, in our state, you can't consider illegally obtained evidence. And by example, hypothetically speaking, because we don't want to get the commitment, question, objection, person gets pulled over for burned out license plate light bulb, officer's walking up to the car, and here's this boom in the trunk of the car, and walks up to the trunk of the car, pops the trunk of the car, pops the trunk open, and there's a beautiful little 6-year-old girl who just got kidnapped, and you believe beyond all doubt that this man had kidnapped a child, but you have a reasonable doubt as to whether that little license plate light bulb was burned out. You're going to cut that kidnapper loose? And then before I get a response, I preface it with the jury that you're looking at me crazy. I was like, let me tell you something. You're going to start looking at me real crazy in a minute, so just hold that thought. And then I go down the line and go, if you had a reasonable doubt as to whether or not the license plate light bulb was burned out, could you let the kidnapper go? And you will just, I mean, you'll have people that just want to get up and kill you, okay? But that, I'm going to talk to you about voir dire briefly, but that's what voir dire is. Better to get that person that wants to cut off your head out there versus over there. And so I view myself as a little punching bag when I'm doing voir dire. And some jurors come in and they think that, you know, that they're going to really get under my skin. It's like, you're trying to mislead us, and this is exactly what we thought we would listen to. And then, you know what I do? I look at that juror and I go, you know what, sir, Mr. Johnson, I commend you. I was like, you know what, this man has to get up here and say something kind of mean to me, but he had the courage to do it. And you know what? The only thing we're sworn to do is to tell the truth right now, and that's what he's doing. Who feels like he does, that I can never follow that law? And boom, 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 guess what? Busted panel. You know, or you get people that really can follow the law. One or the other, you win. So in this case, this was a 3823 case because I ended up with a 3823 instruction. The reasonable suspicion for the stop was speeding. And there was a sign that, I was fortunate to get the jury instruction because it was questionable whether I was entitled to it. The testimony in this trial was that there was a blood test, the blood was drawn at the hospital. While my client was at the hospital, he threatened to kick everybody's ass. And then he told the phlebotomist, quote, I'm going to kill you when I get out of jail. And then we had a it was actually a .17 blood test. And in this case, the cop officer, perfect. Boy, he did a good job, except he put the wrong date of birth in the search warrant affidavit, and he had the wrong driver's license number in the DIC-23 form, which is the form utilized to try to suspend a person's driver's license. And the officer was very proud of the work he did. He had every single letter in the alphabet behind his name. He said E-R-E, and he was like a masterpiece of, I mean, there was a lot of stuff there. I was like, wow, and I built him up, and it's like, man, you've had an esteemed career, you've done this, and you have to go out and do this training on your own. And I went ahead and did these things. Boy, that's really, and you're in the armed forces, so I appreciate your service. Now, I want to talk to you about the big mistakes made in this case. And this guy at this point is just like, it's theatrics, okay? This is a production. These people do not come down here to be bored. They want to be entertained. Entertain them, okay? You do not win by not taking chances. You do not win by not taking chances. If you're trying a criminal case and they're laughing, you're about to win. You're about to win. If this is funny, that's a not guilty verdict. And so in this case, I went up to the officer and like, build it up. It's like, officer, it's like you've sworn an oath to tell the truth. You understand what that means. This is serious business. It's like when you give your testimony, subject to the penalty of perjury. You sign an affidavit. It's the same sworn testimony, right? Police report, you write it. We may excuse you if you lie in your police report. But on these other parts, we don't, do we? No. And that's the way the law should be. Mark them as exhibits. It's like, I want to show you this. It's like, what is my client's date of birth? It's like, I see a mistake. You bet you see a mistake. You swore under oath in this document you were trying to get his license suspended, and you can't even get his date of birth right. Well, it was just, I understand what it was just, okay? Look, officer, let's be honest with each other. We got a little cutting and pasting going on here. Because you told the jury you made how many DWI arrests? 67? Wow, impressive. Numbers mean something to you. And so you're kind of in a hurry, and you're probably cutting and pasting Mr. Smith's stuff and putting it in my client's stuff. And no, it's not what's going on here. I was like, okay. Okay, so we have your sworn testimony here in this affidavit, and then you had the sworn testimony you told the jury under oath. Which one was more the truth? And then he'll tell you something. And believe me, I had a couple more in my back pocket. And so I just sat there, and I was like, okay. And then he's all heated. He's not happy with me. We go through some few more questions. He's like, gosh, you did this test right. Got any other mistakes? And then boom, catch him. And the jury loves it. They loved it. They loved it. They loved it. And then they so had a reasonable doubt as to whether or not he was telling them the truth. Then we got down to the speeding. I was like, where does the speed limit change? Really? Where does it say in your police report that the speed limit changed to that mile marker? It's not in there. So you don't really know, do you? Why do? It's like you talk to the prosecutor about it before trial? No. It's like you don't really know. Ultimately, in that case, I received a 3823 instruction based on speeding, and I was like, this guy can't even get the date of birth right. You got the driver's license number wrong, and now we're supposed to believe him about mile marker 42? It's like, that's not beyond a reasonable doubt. The jury agreed. Got my client not guilty. And so that was a case that I really didn't want my client to go to trial because it just didn't seem like a winnable case, but he wanted to go to trial, and so we just took what they gave us and we dealt with it, and it worked out. That can happen for all of us. It's just don't defeat yourself out of the chute. Don't defeat yourself out of the chute. You can win. Robin Myers. This was a DWI second with a breath test. It was a .09, not such a great video, extract up to .12. And retrograde extrapolation, for those of you that haven't dealt with retrograde extrapolation in DWI cases, the seminal opinion on that is a case called Mata versus State out of the Court of Criminal Appeals. The Court of Criminal Appeals took judicial notice of the science of retrograde extrapolation, taking a person's breath or blood alcohol level at a later point in time, going back in time and guesstimating what they would have been at an earlier point in time. And there's people that have studied this, Dr. Widmark, Dr. Jones, and the Court of Criminal Appeals took the extraordinary step of taking judicial notice of scientific articles that deal with the study of this scientific phenomenon, retrograde extrapolation, and talked about absorption rates and elimination rates. And without boring you, what it means is like tested at a .10 at 1 o'clock in the morning, at 11 o'clock in the evening, you would have been a .14. Okay, that's what they're trying to do. And so that's what they're trying to do in this case. Not the best video, but we had a Houston Police DWI Task Force officer, and this is a lot of good trial prep in this case that we've done. We had gotten the officers MDTs, the mobile data terminals. Understand, It's your job to put, police officers lie. Okay, they just lie. They'll say whatever they want, and they get away with it for so many years because it's rare they come in to contact with a lawyer who's just going to smack them across the face. Okay, it doesn't happen enough. It needs to happen more because then maybe they just wouldn't lie so much. And so we get the MDTs, mobile data terminals. We get the GPS records from the police car. This stuff, it sounds fancy, but it's real easy. You issue a subpoena, get the process server in the court to serve it, and then you got the whole story. Prosecutor, they haven't looked at any of that stuff. They don't even know what you're doing. Okay, they don't even know what you're doing. And so in this case, through getting the MDTs and the GPS records, we're able to figure out geographically where the police car is located at what time. And in this case, they had a solid, appeared to be, based on those records, they had a solid 15-minute observation period because they got to the station 47 minutes before the breath test. Where are we going to go with that? We issue another subpoena that for all the videos inside the police station. And then I get these videos, and these videos have this is so good. These videos have a timestamp on them, okay? And there's a timestamp at the back door of HPD, 0210, where I can see the officer walking in the back door of my client. The officers, and let me tell you something, any sneaky little excuse that they can give you, the clock was off. This was off. Get ready, because it's not your job just to be able to put this evidence forward. You've already got to know what they're going to lie about. You know, earlier this year I had back surgery, so I was out of trial for 2 months. And as a result of that, I've just been in trial every single week. And as a result of that, my sword is very sharp because I'm cross-examining somebody every Monday morning somewhere. And so they've kind of created a little bit of a monster. It's like, sorry, y'all did it to me. But anyway, so the MDTs show what time the police officer gets to the station. Okay, so we know that. We get the GPS records. We know that. Both times the same. Okay, what do we call that? A fact. Okay, that's proved. That's beyond all doubt. Okay, what are we going to have 2 cameras that are off? Because if you don't catch them in that, they're going to tell you the camera's off. Then we have the camera from the back door of Central Intox. They arrive at the station at 2:07. They hit the back door at 2:10. We look at the little timer on the camera at the back door. It says 2:10. What does that tell us? It tells us that all the cameras are right, that the times are right, because they are GPS. They're 100% right with the GPS. Okay? That's right. Doesn't get any more right than that. Then we see our